Hi, folks. I'm Kapil Kumar. I am a director of the 22Q Family Foundation. Our goal is to help create awareness, raise it, increase education, and help people connect. So awareness, education, and connection are kind of our three main themes. We're focused on all families with 22Q, whether it's deletion or duplication. And we like to put on a series of webinars to help people just get ahead of various topics. We have a few that are coming up in February that Lindsay's going to be talking about. We've done a seminar with Donna Cutler-Landsman, who's our foremost educational expert in IEP support. And today we have Mike Webster with us, attorney at law. Mike and I have known each other for, wow, probably over a decade now. Yep. And he's not only our family attorney, but a friend and confidant. He helps us out in a lot of ways, both as a foundation and for my friends and family as we need as well. And Mike today is going to talk a little bit about some of the legal questions and issues that some of our families face. And so, we've gotten some questions ahead of time on legal guardianships, conservatorships, estate planning. And so feel free to chime in with questions, and we'll make sure those get addressed. And I'll let Mike introduce himself while I distract him and set up a light.
Well, good evening or afternoon. It's evening here in the Chicagoland area. I appreciate the opportunity to speak with your group today. By little way of background, I'm an attorney who practices in the estate planning, trust, and estates area. I work with families who across all spectrums of wealth, family issues, children with disabilities, adults with disabilities. I'm also a CPA, and a lot of times that comes in handy in this type of planning that we need to do, because there's some financial and tax issues that have some serious impact on the planning that's necessary. One of the things that I would like to get into tonight is speaking regarding the planning a family should do for their own issues. We tend to focus a lot on our children and the issues we're dealing with there, and we tend to neglect some of the things at home. So we need to, nobody wants to talk about estate planning. We're talking about, death, disability, taxes, all those fun subjects that people like to, avoid at all costs. But it is necessary to address them. We always joke in this area of the practice, it's the people who plan that don't need it. It's the people who don't plan. It seems like, oh, that's when we have estate planning issues. So we want everyone to have planned it and considered what needs to get done, and have no surprises. In all family situations, people will say, in many situations, people will say, I don't have an estate, we don't have a lot of money, why am I working on this type of planning? But it's not uncommon that people don't realize how much money, how much value is in their estates, and then transferring it to the next generation becomes a significant issue. And many of my clients, their parents are still alive, and so there's 2 or 3 generations or 4 generations sometimes that we have to do planning for, because I've watched grandpa and grandma ruin estate plans that we've set up for mom and dad who have children with disabilities, and then all of a sudden a grandparent will pass away and leave money somewhere that is nice, but it kind of ruins some of the planning. And when I say ruins the planning, it's a nice problem to have when money shows up to have to deal with. It's better than the alternative. However, when a child may be receiving benefits from whether it's government benefits or insurance, or from some outside sources, sometimes the influx of new money eliminates those benefits. So it was an unintended circumstance for a good act for grandma and grandpa. So it's really family planning when you do the trust and estate work for a whole family, and you need to look at it multi-generational. to make sure we're covering all the issues and nothing slips through the cracks. It's a complicated subject, so I don't want to drill down so deep that I, put everybody to sleep, which is, I could talk about this all day, and give a lot of, bad war stories and some good results. But I want to really highlight some of the planning that should be done, some of the options that parents have, and some of the considerations that you may or may not have thought about in this type of area. So I want to raise some issues. Kapil and I had spoken briefly that, Andrew, after the seminar, I will provide Kapil with some resources that you could go to and, kind of help address some of the areas. Different states have different laws regarding this area, so it is a little state specific. I'll try to be as general as I can that will address issues in all states, but there may be something very specific that says, well, I'm in Nebraska, and Nebraska doesn't let you do this. I practice in Illinois, and Illinois is pretty straightforward and pretty common of what most of the states allow us to do in the planning area. There are some model rules and model acts that have been adopted or proposed by the estate planning bar and different governmental agencies. And when somebody does something right, it might be Idaho did something right, 20 other states say, hey, this is a good idea, let's incorporate that into our laws as well. A lot of the things we're going to talk about in powers of attorney, whether they're financial powers or healthcare powers, are state law driven, but they're pretty uniform. And people will be concerned, well, today I live in Illinois, but if I move to California, if I move to Texas, if I move to Florida, do I have to start all over again? And typically the answer is no, but it's not a bad idea to make sure that what you have is in compliance with the state, and possibly the state you move to has better rules and more liberal. Sometimes as an attorney, we try to do everything safe. We're overly cautious when we do this type of planning because it's said that estate planning attorneys don't get sued too often because their clients are dead. But there's nothing worse in our practice than dealing with the next generation when a plan blew up. So we want to make sure that everybody understands what needs to be done when you're doing this type of planning.
Well, I'm sure that's a difficult enough time where even if nothing went wrong, people are going to feel like things are going wrong or not their way. And some of the downfalls that you mentioned about estate planning kind of gone wrong, where it's nice to get extra money, but if I understand correctly, there's issues with like Social Security disability benefits at times, right?
Correct.
And so you can't have more than something like $2,000 in your bank account. So maybe you have that's something we can talk about later too, as other options for that.
Right.
Like whether it's an ABLE program or 529 or other things like that. But so one of our first questions was exactly this: estate planning, and what are the things to think about as parents and things to talk about as kind of a more extended family if there might be money coming in.
Right. Well, the first step in the process is mom and dad level, and we'll talk about grandma and grandpa and siblings, what needs to be done. But from a standpoint of mom and dad, sometimes depending on the family situation and the family makeup, there is a child that has special needs and children that don't. And the scenario needs to be discussed of, are we going to allocate resources, at the time of the death of the second of mom and dad to die, to the child that has special needs, more so than the other children? And that's the financial question, but there's also the personal question, and it's really the tougher one, is if a child is dependent on mom and dad, not just financially, but for other life necessities, they're raising the child or the young adult or the adult child, Who's going to step into those shoes when the parents are no longer around? And that becomes a big issue. And so we need to address that. So when I say we start at mom and dad level, is we'll talk about it in two areas. We'll talk about the financial side of it. Then we also have to talk about the people side of it, and who will be, in charge, if you will. And will there need to be, guardianships or conservatorships that will have to get set up upon the death of mom and dad? And mom and dad, you get to write the rules during your lifetime, so it doesn't become a fight. I just went through a family situation where the parents were not together, and the disabled child, and mom had all the legal rights and dad had very few in the raising of the child. Mom died tragically at a young age, leaving behind a 9-year-old disabled child that dad was in his life, but not as a day-to-day caregiver. Well, mom had other children from a prior marriage who were adults that they fought dad, trying to have custody, trying to be in control of the money. And this wasn't a properly planned estate on mom's standpoint. None of this was laid out. None of the discussions had ever been had in this family. And, we were brought in after the fact, and we're trying to work it out. In that scenario, the dad has some superior rights to other family members, but there was no roadmap laid out of who was going to take care of the person, if you will. There's guardianships and conservatorships of the estate, which means the money, and then there is of the person, which means who's going to have the actual custody of a child or be the guardian of a disabled adult. So those are issues that mom and dad need to address. And if you address them in your estate planning documents, we alleviate that issue and those potential fights, upon the death of mom and dad. So we have to think about the players and the people that will need to step in upon, we're talking tragic situations. Mom and dad aren't around anymore, and there may be a minor child or, a disabled adult child that they're caring for. Who's going to be that person? And the raising of the disabled person may not be the best person to watch their money. Mm-hmm. And it doesn't have to be the same people. And in most cases, it's not. And they will need to work in conjunction with each other. So we need to have the discussion when we're doing this planning. Well, my sister is great and she'll take over and she'll raise my son like it was her own, but I wouldn't let her, go to the grocery store with my credit card. So we need to determine it. And then you say, well, my brother, my husband's brother, he's a financial wizard and he'll be great with the money, but all he does is sit at his computer screen all day, and that's not how I want my child to be raised. So it can be different people, and as I said, in most cases it is different people. Then there should be some succession to that as well. I named my sister. She's a great person, but she's 5 years older than me. Maybe that will have a situation where she's not going to be around, for the period of time we need. And we can't, well, possibly we could, but it's hard to predict all of the things that will happen and have enough people lined up. But at least we have a fighting chance if we have the discussion now while we're doing the planning, and we lay out the succession of, this is, first it's my sister, then it'll be my brother, then it's my best friend from when I was a child, and maybe we have an idea there. Same on the financial side, we decide where we want to do it. And so figuring out the people sometimes causes the biggest fights in the family. Oh no, it should be my family. No, it should be my sister. It should be my brother. And we end up creating a lot of stress. And I also recommend, and I highly stress this to my clients, is have that conversation with the people you choose. There's nothing worse than picking someone, and then when they come to me after the tragedy of mom or dad dying, and I say, hey, Aunt Sally, guess what? You were named as the guardian for little Bobby. And she's like, what? I don't want anything to do with that. I love little Bobby. I'm at a different point in my life, and all of a sudden, we caused some other problems in the family. So have that discussion with the people you're choosing, and on the financial side too, and hopefully they know each other or can work with them.
So I'll actually expand on that a little bit. When we were pregnant with our daughter, who's about 18 months younger than our son Niam, who has 22Q, I called Mike and said, hey, I need to do some estate planning, and I still haven't finished that. It's been 4 years. So, one thing is, it's definitely hard to actually just get in to do it. And, we had all the conversations with our family. And so we talked to, my wife and I talked to each other. We talked to the people that we would have selected and we're going to select. I will get you the paperwork soon. And we also had a conversation then with our family, because her parents and my parents, my aunt, my uncle, and my mom, they're at an age where, depending on when things happen to us, they're already not necessarily able to take care of the kids full time, and so it needs to be someone that is both physically, financially, and kind of capable and able and willing to do all of these things. But we felt like it was an important conversation, that we don't want them to find out after the fact that, well, what do you mean we're not going to get the kids? Like, hey, there's thought process that went into it. And do you have any suggestions on kind of like ways to start the conversation, even just with a husband and wife? It can be challenging, and so tips and tricks on that.
Well, there are some natural people that tend to show up when I start this discussion with families, and a lot of times it's not a sibling. It's people will naturally think, well, yeah, it should be my brother, uncle, Uncle Kevin will do it, or Aunt Janie will be the one. But that's not always the best person or the right person. So it really does, it's different in every family situation to do it. Logical, or I don't know if it's logical, right, but it tends to happen is everybody says, well, mom will do it, and then you reach up a generation. And as you said, that's a good answer. And, I have 4 daughters, that twins in there at the end, and we had them all in 39 months. When I had one, we had people lining up that said, oh, well, I'll be the guardian. I'll be the guardian. Yeah. When I had 4 that were, 4 years and younger, there weren't a lot of people volunteering, and then grandma did become one of the logical choices. Sure. But fortunately, we lived. Yeah. I made it till my kids are 18, so we don't have to send them to grandma anymore. But that's still always, it's a tough issue, and families don't want to split up children, but sometimes that's necessary too. It doesn't happen often, but sometimes when there is, a disabled child issue, it happens that way. That we try to address it. But if parents, mom and dad, when you're doing your documents and you spell out these terms and what you want, it makes it a lot easier for the people that you've appointed. And if there are some, some differences of, who's watching the money and who's watching the children, or if we're splitting up a family, I like to put the logic in there and the discussion in the document to the extent you can. So it's not like to offend anyone, that there's been thought put into this process and why we're doing it in this way. There's not an easy answer to these things, and it's a long drawn out process for parents to decide. I keep a box of Kleenex in my conference room here because we get a lot of tears when we start discussing this. Well, what happens if something happens to both of us? Who's going to do this? And it's not an easy discussion to have, but I think it's very necessary. And that's on the personal side, figuring out the players, the people. But then we start talking about money, and it's a whole different ballgame and a complicated area. Yeah. But it really needs to be addressed. And some people will stress that, hey, that's the most important part. We have to figure out how things are going to happen financially. But I think the people side is very important, if not more important, in my opinion, because I've watched a lot of the plans I've written over the years fall apart because of of the
people
wrong
side, yeah.
of the wrong side choices on the people side of it, and it makes a difficulty on the people who you've appointed or asked to be the guardians over a period of time, and the effect it could have on their family and their lives. So you really want them on board and understand what they're getting into. Sometimes it is a sibling who has comparably aged children of yours, and your kids may end up being rather wealthy compared to their children because they now have inherited all of your wealth, and your sister who is raising them, her and her husband, are still using their wealth, so they haven't passed it on to their kids. So it ends up being sometimes a sticky situation where
Create some additional issues that may not have existed beforehand.
right. I mean, I had a case where that happened. Mom and dad, one was an accident case, and there was a lawsuit. So the children are really wealthy. They don't have mom and dad, but they have a lot of money, and they're being raised by a sibling who has comparably aged children. And she tries to treat everybody the same, but we got to college age for one of them, and it's a very intelligent child and has great offers to go to big schools. And the guardian is struggling with it because she's like, yeah, we can afford to send her there, but I'm not going to be able to do that to my kids. We're not going to have the wherewithal to do that. So it does cause some issues. So we need to always be aware of that in the planning, and at least address them up front. And sometimes when you split the money with the person who watches the money to the person who watches the body, it makes that a little easier for
Takes away that kind of struggle from the person that's watching the body,
right,
from having to differentiate. Then it's like, hey, it's not, I don't have any control over this other person.
right.
Just quickly, we have a few people on with us, and so if you're joining from a computer, there's a little menu at the bottom. You can click the chat button to ask questions. If you're on a cell phone or an iPad, if you just tap on the screen, there's options, and you can click on the chat. So Mike, let's just use us as an example, and figure out, like, where should we start, with the person or the money? Like, does it depend on the family situation, or is that kind of like, is it, you said sometimes the person is more important. So should we start there, or?
Well, I like to get people to get their work done,
Yeah.
and get this planning done, and usually it's the person side of it that's holding it up.
Gotcha.
So for the procrastinators in the world, let's do the easy issue first. Let's talk about the money.
Okay.
Because there's some planning that needs to go into place for the direction of the money when the child, when the parents die and we're leaving money to the children. I'm a strong proponent of, I don't care who the child is, what the child's age is, what the child's health is, if there's disability, whether the child's receiving benefits or not. I've been doing this for so long that I've watched so many kids inherit money and screw themselves up and have trouble, or spend the money frivolously and it's all gone. That I think there needs to be some control on every child who inherits money. And I don't care if they're 7 years old, or if they're 17 years old, or if they're 47 years old. I just had a family where 3 children, all in their 40s, inherited about, close to $1 million each from their mom. And one of the daughters, within 2 years, had spent it all, and now she's knocking on her brother and sister's door all the time wanting money. It can get complicated. I had a situation where a family where one of the child had an addiction problem, and the money that was inherited by him was his death sentence. He didn't make it because he had the wherewithal to fuel his addiction, and it was the end of him. And if the parents had just planned, so what you have control over, your resources and your wealth that you're moving to the next generation, is to continue on the family legacy, and this money that goes to the kids. It can be put into a trust situation. We call it a contingent trust in estate planning, and when you're reading, you'll probably see those words pop up. And then the contingency is you get to define. So the contingency in my estate plan was if my wife and I die and my kids, any of my children are under 25 years of age, nobody gets anything yet. It all stays in a big family pool. And I picked 25 in my case because I wanted to get everybody through school and at the starting point in life. There might not be anything left by the time the youngest are 25 years old. Maybe it all got spent in college. Right? Maybe it all got spent in other parts of life just raising them. Yeah. And there's nothing left to split up. Instead of when we die, split it up in 4 pieces and everybody gets their 4 pieces. Well, that wouldn't have worked well in my case because my oldest graduated from college, 3 months before my twins started college. And if my wife and I would have died at that point in time and split it up in 4 pieces, my oldest would have got to take her inheritance and put it in her pocket. And the other 3 would have had to use it to pay their tuition. Where the oldest got free tuition and then got the money. So we want to, have the contingency. So my first contingency was I want everybody to be 25 before we start splitting it up. Then I split them and I had some other contingencies in there. So I took it up at 25. When they all make it to 25, then I will split it into 4 pieces. And then each of those trusts have provisions in them that said, hey, you can have the money for this reason, for education, for healthcare, for, support if you don't have other means of support. And mine's pretty specific. I do this for a living. I kind of define if you need it for your support, great. But if you're a bum, that's not needing it for your support. I want you to go to work. I want you to have, and I've appointed a trustee, a non-family member, to be the arbiter of that decision.
What does that mean? Like, what does it mean to be a bum in 20 years, for example?
Well,
right?
Yeah.
Yeah.
And then in that scenario, I'll carry it one step further. Then when I split it up into 4 piles when they're 25, then I don't give it to them outright. It sprinkles out to them. They get it over a period of time, over a period of years. So if they make a mistake when they're 26, they didn't waste it all. Maybe they wasted 1/10 of it. Maybe they wasted 1/4 of it, depending on what you want to give out to them. But during that period of time until it's fully distributed to the child, it stays in it's their money. It can be used for their benefit, but they have to go to somebody to say, hey, I need the money for this reason. I have a close friend. He's my business partner for 30 years. He's my trustee. He's watching the money for my kids. And they can go, hey, Uncle Jim, I need $25,000 out of my trust fund. What's that for? Oh, it's because I'm going to go to graduate school next year, and that's what the tuition. Oh, that's a great idea. Here's the money, even though it's in trust and you don't have control. I have control, and I like that reason. Child 2 says, wow, that worked for Cassie. Maybe I should get some money. Hey, Uncle Jim, can I have $25,000? What do you need that for, Emma? Well, my boyfriend and I want to buy Harleys and get tattooed and go live on the beach for 3 years. Right. And spend the money so we don't have to work. No, I don't think that's a good idea. So you get to write the rules again. Those are the contingencies I put in there. So these trusts are contingent. Mine say if my kids are all 40 by the time I die, I didn't put any more rules. I figured I have a magic date. I don't know why 40. Maybe when they turn 40, I'll change it to 50. I'm not sure what the logic is, of what certain people choose. I have parents who choose. I have a wealthy self-made client who has what he calls the dollar for dollar trust. He's going to put a lot of money in trust for his son, only child, but he doesn't want to spoil him. So he said anytime he wants $1 out of the trust, he has to be able to match it. So if he wants to buy a car and he wants $25,000, he has to have $25,000 of his own. Or if he wants to buy a $25,000 car, he needs $12,500 and the trust will give him $12,500. If he wants to go to school and tuition is $20,000, he needs $10,000 and the trust will give him $10,000. You can write the rules and you get to. But these contingent trusts, they're contingent because they may never come into play. You wrote them in your document that said, if this happens and this happens, if my kids are all under 25, if they're all under 40, all these different contingencies, here's what will happen. If we're past those contingencies and none of them happen, then the money just flows out to them. So that's, I think, for every child, depending on disability, financial needs, to have some type of control at the death of mom and dad is a good thing, because it's important that we don't know what their situation is going to be at the time of the second death. And it may be something beyond their control. Maybe they were just in a bad car accident and it was their fault and somebody's suing them, or just got a judgment against them and they owe $1 million. And if they inherit the money from you, immediately somebody else is going to take it from them. Well, we wouldn't want that to happen. If it sat in one of these contingent type trust arrangements, it could stay there until that problem went away. It could be used to negotiate that problem away. It might stay in trust forever for that child and be a pseudo parent, the trust that you've created. The trust could buy a house that the child could live in. The trust could buy a car that the child could drive. There's some things that you can do in that type of estate plan. So that's kind of, I said I wasn't going to get too detailed and into the nitty gritty, and there I went down that rabbit hole. But that's kind of basic estate planning. You know, in your group of, you know, what the listeners today are dealing with is we have an extra layer of protection that we need to put in there, because as Kapil said, you know, in the introduction, sometimes the child with disabilities, if they're receiving some public assistance, if they get any money, inheritance counts, it blows that right out of the water and you don't get that anymore. And then you have to spend all your money before you can be entitled to it. Is there anything wrong with that? You know, if you've got it, should you be getting government assistance? I'll let you guys discuss the politics of that one. But if you're getting it, I'd sure hate to lose it when you don't have to. And there's been a lot of planning that's been done and approved by courts, approved by states, legislatures, that become part of the law that said if you follow these rules, you don't lose those benefits. So let's just follow the rules. And what we do is we set up trusts for the child with the special needs or the disability or is receiving the benefits, that the money is the receptacle of that, and it really never does become their asset. So it never goes into those calculations for counting whether you're entitled to any kind of public benefit. So that's why I always say, and it's important for grandma and grandpa to understand that too, because it's not uncommon for grandparents to say, I'm going to leave, I'm going to split my estate to, you know, most of it to my 3 children, but I also want to give this piece to my pool of grandchildren. Well, that could have the contrary effect of, you know, the planning that you want to do, and could put a hardship on, you know, mom and dad. Grandma and grandpa did that. So we want to make sure that that money is protected as well. So typically, this kind of trust that I'm talking about isn't going to be a contingent trust, because we already know the contingencies exist. So we draft that trust today and use that as a vehicle that could last for a lifetime. So if I have a child that has some special needs that she's receiving benefits from the government right now, I would still do my will and trust or whatever my estate planning my wife and I would do, but I would create the child trust today that could be the beneficiary of anything grandma and grandpa wanted to leave it, anything a brother or a sister, because it's not uncommon in family situations that has a child with special needs that has, you know, some extraordinary costs or potentially extraordinary costs in the future, that other family members want to help and contribute to it. And I say, how can we do that? So we set up a vehicle today. So I would set up, you know, my daughter's trust today with these terms. While I'm alive, I can be the trustee of that trust. Me and my wife, or I could pick somebody else.
Yeah.
So I can control it. And it has the terms of how we want money to pay out. And the terms will be written in such a way that it can't be paid out if it impairs getting, you know, the public benefits that you're receiving.
You can build it into the rules of the trust.
In the rules of the trust. And it doesn't mean that the trust can't be used for that. But when another term that you'll see in readings, they call them supplemental needs trusts. So it's not there to provide for the primary needs, but to provide for the supplemental needs of the child. I've had trusts that are set up like that with the child in public assistance. I've had a child that's living in facilities that hardly anything is being paid by the family. They have this big supplemental needs trust off to
Anything
the side
outside of
for
those
anything
things.
outside. The kids can have a TV in the room. They can have a computer. They can have assets. They can, extra spending that can be used for the child out of that trust, but it's not the child.
What would you say are the kind of like the few most common types of trust? You have a contingent trust, one of these supplemental needs trusts.
Right.
What are the other types of trusts that
Well,
we
then-
can know about?
Yes. Then there's some, when I say big, these are ones that have been approved by like Social Security Administration. They've been approved by, states, legislators said, if you follow these rules, it's not going to affect your benefits. And a lot of those trusts come into play when money is, let me back up one second. There's two kinds of money that the government looks at in these benefits, what they call first party money and third party money. When you inherit something from grandma and grandpa, or you inherit something from your parents, that's third party money. Somebody else is giving that money to you. There's a lot of latitude in that type of money. And those are the kind of trusts that I was just explaining, that we can set up now, we can set up rules, and we don't have to worry about that money being spent down to
Keep the money that's coming from someone else that they haven't earned or gotten for themselves.
Now, first party money is your own money. So if I were in a tragic car accident right now and it was somebody else's fault and I have a traumatic brain injury and I'm never going to be able to function, and Kapil now is going to have to be my guardian for the rest of my life, and he's going to have to take care of me, but I'm going to get a $5 million lawsuit settlement. So I'm going to have all this money come into me. Well, it took 4 years for the lawsuit to get settled and the money to be funded. And during that 4-year period, I've been in an institution. I've been receiving public assistance. I've spent all my money, or my family's got it all, and I don't have anything. So I'm getting assistance. But once this $5 million come in, the people who are paying for me right now, the government is going to say, oh, we don't have to pay anymore. Yeah. Well, there's a procedure out there that said, this is first party money. It's Mike's money. He's getting it. Well, if we follow all these rules, they'll put the money in a pile that Kapil gets to watch for me, for my supplemental needs. I can still continue to receive my public assistance, but that trust has some rules in it that says when I die, I might have to pay some of the money back to the government at my death, what's in that trust. So our goal during the rest of my lifetime, and Kapil doesn't know this yet because he just got appointed my trustee, is to spend all that money.
Right, so you don't pay it back.
So we don't have to pay it back. Spend it to help my family, to help other things, to help, that are helping me.
Right.
Hire my wife to be my caretaker and give her a salary. Hire my friends to take care of me.
Yeah.
Buy me somewhere where I can live, that they can live for free, and then they don't have to pay
Their
a
own
mortgage payment.
expenses, right, yeah.
So they can accumulate money, and we use this money. Those are called, they've got street name called a payback trust. It's the section of the law that made it is D4A, so people will call them D4A trusts, but they're special needs trusts. Now, those are extraordinary cases. That's when money's coming in to the disabled. But that gave us a lot of direction to handle these third-party trusts. If we follow a lot of the rules,
all of these things,
we won't lose our public benefit, because there's a lot of rules in the first-party trust that says you can't do this, you can't do that, or you're going to lose your benefit. So we put that into the third-party trust, but it doesn't have the payback provision at the end. So that third-party trust says if there's anything left in that trust upon the death of the person who's the beneficiary of it, the disabled person, it gets to go wherever they said in their will or whatever the trust said. So that's wealth that can stay into the family. So when we have that first party trust, we try to use it legally, but to get money out of it, because there may be a payback at the end. So that's an important distinction of keeping the first party money and the third party money. Most of what we're going to be talking about, or that everybody listening to this, is it's going to be potentially third party money. Right. If your child goes to work, that had the disability and makes money, that's first party money. You can't really, it is what it is. They're going to have to spend their money just like any of us.
And can they deposit that money into one of these trusts, so that, like, as a first party money into a trust, so that they don't have to worry about Social Security? disability.
Well, if they're working and earning, they're probably not entitled. They're probably not receiving those benefits at that point in time. So really setting up a first party trust typically will come from lawsuit type settlement money.
Got it.
But what's more important for our discussions and what's more is the supplemental needs trust that we were talking about. So the third party trust. Mm-hmm. And that really should be the vehicle that we use. And that's the vehicle I use when I have any parent doing an estate plan that has a child that has special needs. Or, you know, we're going to have some long-term financial needs and potentially have some government benefits that could come their way. So the money's never in their name and accountable to them.
We have about 20 minutes, and one of the families asked, is there specific planning that you need to do in preparation for the possibility that your child will need additional support as an adult? Or is it just a matter of having the financial resources? Or do you need to have a plan for a lawyer that can assist your child in addition to a family member? And so, you know, that's a few different questions. One is, you know, I guess let's talk about the person aspect of estate planning and how to help make sure that the person is taken care of, the people that you're leaving behind, especially if you have a child that has some additional needs. And then also, you know, not everyone has you in their field of resources. And so how do you find the resources to try and be able to have these things in place?
Well, use me as a resource. I have connections. I'm in some organizations that are national as well. There's estate planning attorneys, elder law attorneys. Excuse me. That is true. Just because you went to law school doesn't mean you know what's going on in the law. Please don't ask me a divorce question. Don't ask me a medical malpractice question because I can't answer them. But I specialize in this area. There are people that specialize in this area all over the place. As I said, you can use me as a resource and hopefully I could direct you to someone in your area that could help. Ask the questions to your attorney. Just because they represented you when you had a speeding ticket when you were 17 years old doesn't mean they can write your will or your estate plan. Just because they wrote your will or estate plan doesn't mean they can help you with the speeding ticket either. So keep that in mind. But there are organizations, you know, through bar associations in most areas that have a referral list as well. It's easy to get on referral lists from a lawyer standpoint, but at least in my area, they vet us pretty well to make sure that we really do know what we're talking about when we say we're an expert in this area. But be cautious. Referrals are always the best way to find someone. And as I said, contact a local bar association, and as I said, I will provide some resources as well that maybe people can find in their specific areas. Someone to help.
Okay, so now let's talk about finding ways to help make sure that, you know, your child with additional needs is taken care of, and kind of how to assess that progression, right? And so one of the issues, for example, that kids with 22Q face is, you know, there's a percentage of them that may have psychological issues, including schizophrenia, and that doesn't show up until like your 20s, mm-hmm. Right? And so, you know, for me, who has a young child, how do I think about this now? Obviously, these plans can be updated over time as new issues emerge, but, you know, the whole point is contingency planning, right? And so let's say something happens to me before he turns 25 and he ends up having psychological issues. And so how do I think about that today, not knowing what the resources will be? Let's say that, you know, something unfortunately happens to my wife and I, and we pass early and there isn't that much money left behind. So how do we kind of approach that?
Well, first we take care of the money that we know about. Yeah. And my number one recommendation is that special needs trust, the third party trust that I discussed. I would definitely have that in place. That trust can be created in your estate plan, in your will, as a contingent trust. They're more complicated than the contingent trust that I was describing for not giving your child the money to buy the motorcycles. And I have nothing against motorcycles. But this type of trust for a disabled child or potentially disabled has a lot more rules to it. So I like to make that, in my planning, a standalone instrument. So mom and dad have their estate plan, whether it's wills or living trust type documents. That beneficiary, child one, goes through my contingent trust thing. But child two, who has the special needs and potential long-term care issues, the beneficiary of that is not that child. It's the child trust that I created at the same time I was doing these other documents. It's just one more page in your estate plan, one more tab in the binder. And as Kapil said, every document that I've talked about, except for that first party trust when you're getting the lawsuit money, is a revocable document. They can be amended, it could be changed, as long as the person who wrote them, the grantor, which is mom or dad, is alive. So as long as you're alive, you can make these changes. So as things in life happen, you could throw it away, revoke it totally. You could tweak it. You could change the people that you've decided you want in there. So those documents can be changed. But when we talk about the contingency of, okay, we died prematurely, I've written all these documents, now they've all become irrevocable because the people who wrote them are deceased. So now we have to live with them. And so we have to really use the best facts that we have today to write that document. And it's a document that's living. They call them living trusts, not because you do them while you're alive, but they're living. They change, they evolve, and we have to do it. So anybody who you work with to draft this type of estate plan, you should have an ongoing relationship. So when we draft yours, ultimately,
one day,
we will discuss it. I mean, you and I, it won't be a bigger problem because we talk a lot, but I have clients that they write them and they want to put them on the shelf, and then they never call me again. Well, I bug everybody at least every 2 or 3 years just to say, hey, is everything okay? Remember we did this. I have a nice little form letter I send out that said, this is who you named as your trustees. This is who you named as your guardians. Still like all these people? Are they still the players you want to keep playing in the game? And we just kind of update it and make sure it stays alive. But that's really, the duty is not so much on the person who drafted it. It's on you to make sure that these documents stay alive. The question about financial resources is one that I get all the time. Like, how are we going to fund this? You know, I'm taking care of my child, you know, through their, you know, youth.
Yeah.
But when they turned 18, maybe they're not going to be independent in their life. So they're going to live with you forever. Well, that's a whole different, you know, scenario that we have to do it. I'm not an investment advisor. I'm not a life insurance salesman. But I've had clients who buy a specific life insurance policy, the second to die ones on mom and dad, that said, when the second one of us dies, some insurance is going to show up, and they fund this special needs trust, this third party trust, with those insurance proceeds. They do it for a couple of reasons. One, they have 3 other children and they don't want to take 100% of the resources to put it in the trust for the disabled child, even though that's what it's going to cost. And if mom and dad would have stayed alive, they may have utilized their entire estate and not given it anything. There wouldn't have been anything to give to anybody at mom and dad's death. But if they die prematurely, they don't want the kids to say, wow, why did Johnny get $1 million and we didn't get anything? Or why did Johnny get $10,000 and we didn't get anything? So they'll use insurance. People will use beneficiaries of their retirement plans to fund those trusts. I've had clients who have given the house to that trust that then they let the guardian live in that house. So it helps ease that burden for the guardian, but it's really that child's house that the guardian lives in. And ultimately, and then because we get the right to rules to that trust, if something happens to the child who the trust is set up, then it goes back to the other children. So we try to funnel money, as much money. We can't anticipate, you know, everything you're going to need, but you know, you do the best you can with the resources you have. And I'm not a big proponent of life insurance myself, but when my kids were young and my wife was raising them and I was the breadwinner, I had boatloads of insurance because if I dropped dead, I wanted everybody to be taken care of. Now that everybody's kind of almost on their own, that need's gone away, and I don't feel the need. But there was a time in my life, and there's products like that. Now, if you have a child who's going to have, long-term care issues and you're fully dependent upon you, maybe that need never goes away. So so insurance might be something to at least consider. And it's not insurance on that child, it's insurance on mom
and dad, right? So you mentioned guardianships. Can you talk a little bit about guardianships and conservatorships and, how that is contrasted with letting kids be, independent, or young adults to be independent?
Right. You have a guardianship or a conservatorship when you don't do your planning. Those are court-imposed rules. They're the ones when, if you write your will and say, here's where the money's going, and I'm appointing Uncle Bill to be the trustee to watch the money, we don't need a conservatorship because nobody has to watch the money. You already wrote the rules. If we have someone being a guardian until they're 18, the court's still going to be involved, but it's you got to pick them. It's not 17 people running the court saying, I'll be the guardian, I'll be the guardian. Because when there's a big fight like that, at least in the jurisdictions I practice in, the judge picks the least obtrusive way to do this. So if 3 siblings are fighting about it and somebody independent is there, I'm going to the independent.
Yeah, right.
If 3 siblings are fighting and they're really bad and there is nobody independent in there, the court will appoint the public guardian, which is a political position in my jurisdictions. And that's the last person I want raising my kid as the public guardian. So I'd rather have it be the family. Now, if we get to the stage of a disabled adult, there may need to be a guardian of their person to take care of them for the rest of their life. And that is a court proceeding. That's not one where somebody didn't plan right. It's just, that's the rules. But that's an easy one because all the court wants to know is, are they seeing the doctor? Are they healthy? Are you making sure they have a roof over their head? It has nothing to do with the money. That's where the guardian of the estate or the conservatorship comes in. And that is brutal. Actually, from a lawyer standpoint, it's a lot of fun to be the attorney for conservators because they usually have a bunch of money of the ward of the disabled person. And the court's going to approve attorney's fees because somebody's got to do all this paperwork in this mess. And the conservator is spending other people's money because it's not theirs. Right. And they call you all the time and say, hey, I need help with this. I need help. I don't want to do all that. You do it. Yeah. Well, we do all the work and we make a lot of money as lawyers. That's not the practice I want to be in. So I help plan the estates right where mom and dad, you appointed this person, not the judge, not the court. And we don't have to have oversight by the court of the financial side unless the conservator goes bad or your trustee goes bad and starts stealing the money or do something. But their name is trustee, so I hope you pick someone you can trust. Yeah. and there's oversight. There's oversight there if needed. But generally speaking, a well-planned estate, person watching the money doesn't have any court oversight because it's not needed. And the court oversight's expensive.
Yeah. Okay. If we have any other questions here. No other questions so far. So what else can we, how familiar are you with the ability to use, like, obviously you're familiar with this stuff. So we talked about trusts, and just so I make sure I understand this point correctly. So conservatorships are typically based on the money part of it, and the guardianship is for the person.
Right. Okay. And different jurisdictions call them different things.
Slightly, sure. Yeah.
In Illinois, the big thing they call them, we don't use the word conservatorship that much in Illinois. We call it guardian of the person and guardian of the estate. Other states will call it.
Why make it complicated, right?
Yeah.
So say what it is.
So those are the rules, that lay it out.
And then, you have things, so we talked about special needs trusts, we talked about contingent trusts, and we talked about kind of the difference between irrevocable and revocable trusts versus living wills, which are obviously living, breathing documents. Again, it's not for the person, it's for the document, and the importance of continuing to keep it updated. How do you fit in like an ABLE type or a college saving 529 type plan into these things? Is there, does that count as their money from, a Social Security disability perspective, or from some of these state rules? Would college savings plans be third party money, I'm guessing?
Well, it's actually in the name of the person. So the college, the
Because it's
investment
for the benefit of
of
that
that person.
child.
And there's specific ways that money gets paid out. So it's not like having it just sitting a pile of cash in a bank account in the child's name. But it is countable money for a lot of different rules. And the financial people out there are going to get mad at me, but the investment advisory people, a lot of times these 529 plans, people save really great for the kids for 529 plans. And then it goofs up all their scholarships and
Yes.
financial aid packages.
Yes.
Guilty.
Yeah.
I saved for my kids, and then when I had to put all that on their FAFSA forms, I'm like, I
Man.
should have done something
Right.
a little different. Because kids' money, they figure they can spend all of it on college. Mom and dad's money, they allocate amongst the family, so you don't have to. But that's to the side. Beyond the scope of this
Yeah.
this conference.
Good.
But one of the things before we run out of time, I do want to mention for mom and dad, and then kids once they reach the age of 18, powers of attorney. Mom and dad, if you don't have a power of attorney for yourself, get one. There's two of them in most states: medical power of attorney and a property power of attorney. You want to get into a guardianship or a conservatorship on your life, don't have those two documents. If you become disabled, you're in an accident, or you have a health issue, you have a stroke, and you don't have those documents in place for yourself, your spouse is going to have to go to court to be appointed the guardian of your person and the guardian of your estate, a conservator of your estate and the guardian. If you have these two documents, you can avoid that whole court experience.
Wow, okay.
Anybody who has a child, day after, for their 18th birthday, wrap up in a present for them a healthcare power of attorney and a property power of attorney, naming you as their agent in the event of a death or disability. The second I sent my kids off to college, I made sure they signed them and gave them back to me. So if they were ever in an accident, if they ever had a health issue, if you ever needed to talk to the doctor when your kid's in college,
Just be like,
here's my power of attorney. I've already got that authorization. It's important, but you should have them for yourself. We have a greater chance statistically, and I don't remember the numbers, of needing an adult guardianship than we do needing a death probate. You have a better chance in your life to be disabled at some point in time than you do to die. Now, I know that's when you're 40, and when you're 85, you probably have a better chance of dying. I don't know. But, and the beauty of the law business is a probate is a one-time deal. It might take you 6 months, might take you a year, might take 5 years to get your assets probated after you died. The guardianship conservator court is the same court that handles the death probate. They call them living probates when it's a guardianship. The death probate the person has died and it's going to come to an end. The living probate will last the rest of your life if you're disabled for the rest of your life. I have a 17-year one going on right now that I've been with the family. And the husband had a stroke at 51 years old.
Wow.
And his wife is the guardian of his estate. And we have to go to court once a year.
Reaffirm and
give an accounting of all the money, what came in, what went out, every year.
And that's just unnecessary because it's your money. And
it's a husband and wife.
Yeah, it's a husband and wife. And
the wife had to be appointed to take care of her husband. And so if you can get those documents done yourself, you can buy them in a bookstore. You can download them online. Almost every state has them where you can do it. Just please do them.
Okay, so I have some notes here, and I'm going to make sure that I cover these things properly, and we'll just do a little sum up. Okay. So first and foremost, let's make sure we have power of attorneys. We have the medical and the property, because if anything happens, you don't want to have to go through the guardianship or conservatorship process. And so power of attorneys are important. There's a few different kinds of trusts that you can set up as part of your estate planning. And there's kind of two sides to the estate planning when you're looking at the next generation. That's one is the money side and the other is the person side, in the event that the kids are under 18 or are going to need longer term care. And so we want to make sure that we lay out both of those scenarios. And so on the person who's going to be taking care of that and the money who's going to be taking care of it, it can be the same person, but best practice seems to be to have them as separate people, and it reduces some of that conflict of interest. Okay.
There's not always two people.
No.
In situations, there's not.
Sometimes it just works, and it's great. But in the event that there's potential for conflict of interest or conflict within the family, creating other issues than it could be, or just a level of trust, right? That's what it comes down to. Is
Exactly.
who do you trust with your money? Who do you trust with your physical care of your kids? Okay. And then there's a few different kinds of trusts. So we have a special needs trust, which is kind of first party money, right? And that's going to be things that have come in from lawsuits or damages that are going to be populated in there. And you want to try and probably use that during the lifetime of that person prior to them passing away so that you don't have to do any payback. And then for third party monies that come from other family members, for example, those things can be passed on then based on the estate planning of the person that is the beneficiary of that trust. Okay, and then those are the revocable trusts, whereas you also have contingent trusts that aren't necessarily set up or funded before you die.
Right.
These things are ideas that are documented, and you have rules about how you can use them, and they're funded when you pass away, depending on meeting certain criteria. So there could be a scenario where the kids are very young and you have rules on this money for the next 20 years of their life. Or it could be that they're old enough and all of these rules have passed and they just get the money.
Correct.
Okay. And then
He was listening.
and then there's obviously a lot of resources. And so, we will be able to share those. We'll share, our contact information, and we can pass on questions to Mike and connect people as appropriate. But the most important part, aside from getting power of attorneys and the documentation done, which I haven't done, is to have the conversations. And
Correct.
I think that's probably the hardest part, because it's something that people don't want to think about or talk about. It's, it's a worst case scenario. You just don't want to go there. But it seems like it's just so important. We've met so many families, and, Lindsay and I went to Nationwide Children's Hospital in Columbus. And, that was one of the biggest questions is, hey, our child is 20 or 25 and is living at home, not able to work, is getting Social Security disability insurance. And, if something happens to us, we don't know what to do. And so that's why I think, it's important as a family to be comfortable talking about it, but also to find people like Mike that, you can just bounce ideas off of, and, ask the seemingly stupid, which are really not stupid because they're super complex questions, and be able to get it figured out. And so, like Mike said, there's a lot of national resources in a variety of different ways that can be helpful, that can provide guidance. A lot of these forms even can be downloaded. But the second step then is not just making them and establishing them, but to make sure that you keep having the conversations and keep them updated. I know that's one of the areas where a lot of people that I've known end up getting stuck. They make their document at one point in time, and 15 years later they haven't touched it, but everyone's circumstances have changed. Their kids are grown and potentially married. They might have grandkids, and yet the document is still the same as it was over a decade, almost 2 decades ago.
And you're stuck with it.
And you're stuck with it because if you pass away, then it becomes irrevocable. That's what they left. And so I think the last part too is being able to talk about these things with grandparents and siblings and siblings, your own siblings and your kids and the kind of beneficiary siblings, because it does make a big difference if money comes in and all of a sudden it's in the child's name as opposed to, or the beneficiary's name as opposed to the name of the trust, because then the state's going to want to know, well, how are you receiving this assistance from us? You have this money, or why did the account go over? So it's hard to talk about money just as much as it's hard to talk about estate planning. But there's reasons where I think it's just it makes it okay. It's a context and the way you frame it. Like, hey, we want our child or your grandchild or your brother, sister, whatever, to be well taken care of, and their needs to be met over time, and to not end up depleting resources unnecessarily. So if we can get some assistance, let's find ways to do that and get them the best supports that they can in order to make this last as long as possible.
Exactly right. I mean, you're protecting your children your whole life while you're alive. We don't want to just throw them to the wolves if something happens to you.
All right, so I'm going to commit to getting this done in the next few months. I've committed, next week is probably more reasonable. And I have actually told Mike several times that I'll get it done in the next few months, and here we are. So we'll see. We'll let you guys hold me to it. We'll go from there. But all right. Well, Mike, thank you. This was great, and we really appreciate it. Well, great. Thank you for
inviting me to speak with you. And as I said, I'll give Capel contact information. Anybody has any questions, please feel free to call me.
Thanks for watching, guys. Take care. Bye-bye. Bye. How do I stop it? There we go.